Papers and registration, please.
Hi there, I'm attorney Jay Ruane, and I help Connecticut drivers fight traffic tickets and protect their licenses, their records, and their insurance rates. Before we start, I have one small request. If this video helps you, even a little, please take 7 seconds afterwards to leave a 5-star Google review for my firm. It really helps other drivers find honest information instead of bad advice online. I'll send you the link at the end, and all you need to do is 2 clicks. Super easy. All right, let's get into it. The Connecticut ticket process. Let's start with what actually happens when you get a ticket in Connecticut. Step 1, you get the ticket. That ticket lists the charge, fine amount, and your response deadline. But what most people don't realize is that you're only seeing half the story. The ticket you get is the front half. The backside, or the officer's digital notes, often has the real details prosecutors rely on later. For example, I've seen tickets that look simple on the front, but the back has comments like driver argumentative or admitted to traveling 15 over. Those notes can shape your outcome, and you won't see them unless you request discovery later. So remember, the ticket you see isn't the full picture. Half the information about your case is hiding behind the scenes. Step 2, you plead not guilty. You can do this online through the Centralized Infractions Bureau, the CIB, or by mailing the form that came in with your ticket. Make sure you do it on time. If you miss the deadline, the system automatically closes your case, treats it as unpaid, and suspends your license. Then you'll have to pay a fee and go in person to reopen it. So don't ignore it, even if you think you'll deal with this later. This step only takes 5 minutes, but it saves you weeks of frustration later. Step 3, you get an offer. After you plead not guilty, the CIB sends an offer to resolve your ticket, often by reducing the fine or charge if you just accept responsibility. It looks tempting, but accepting that offer is pleading guilty, and that plea can raise your insurance rate for years. So don't take the easy deal without understanding the long-term cost. And there is no negotiation, just a take it or leave it offer. When I talk to clients who come to me after they've paid, I often hear, "I didn't know paying meant admitting guilt." Well, that's why you're watching this, to make sure you know your rights and your options. Step 4, rejection and scheduling for trial. If you reject the offer, your case leaves the CIB system and is scheduled for a remote hearing before a superior court magistrate, a licensed attorney who acts as a judge. That hearing is your trial. Here's a crucial detail most people miss. You won't get any evidence unless you ask for it. The state doesn't automatically send the officer's report, the radar logs, or the body cam footage. You have to request discovery, and we'll cover that shortly. Once your ticket reaches a prosecutor, they review your driving record, the officer's notes, and the calibration records for the radar or laser speed device used. They'll also look at whether this officer tends to write solid reports or make mistakes. Prosecutors are looking for efficiency, not necessarily fairness. So the more organized you are, the better your odds. When you or your lawyer show up for the hearing online, the magistrate and officer sees right away that you understand the process, and that usually changes the conversation. Here's some do-it-yourself defense tips. Step 1, enter not guilty early. This buys you time to prepare and stops the automatic suspension process if you ignore the ticket. It also shows you're taking it seriously. Step 2, gather your evidence. Take photos of where you were stopped if possible. Focus on signs blocked by trees or construction. Photograph confusing intersections or missing markings. Check the weather for that day. Rain or glare can affect radar readings. Order your driving record from the DMV. It's quick, cheap, and shows you're responsible. And write everything down while it's fresh. Details fade, documentation wins. Step 3, prepare your statement. Keep it calm and factual. Judges appreciate preparation, not passion. Here's a bad example. The officer was rude and had no right to stop me. A better example, I believe the speed reading may have been inaccurate because traffic was merging and I braked immediately. Simple, credible, respectful. Step 4, know what not to do. Don't skip court. You'll lose automatically. Don't pay early. That's a guilty plea. Don't argue feelings, argue facts. Don't assume the radar is wrong without proof. And if this sounds like a lot, you're not alone. Many people hire us for exactly this reason, because handling discovery, paperwork, and hearings can feel overwhelming. It's my job to know how the system works, and I'm happy to take on that burden and take it off your shoulders. Step 5, understanding and requesting discovery. This is the most overlooked part. In Connecticut, discovery isn't automatic. You only get evidence if you ask for it in writing. Discovery can include the officer's narrative or notes, radar calibration certificates, the officer's training records, dash cam or body cam footage, the DMV abstract that's going to be used against you, and any supplemental reports. Send your request to the state's attorney's office listed on your trial notice. Include your name, ticket number, and date of incident. Always keep a copy. If you don't ask, you fight blind. If you do, you might find inconsistencies that win your case. Why many people hire a lawyer. You have the right to represent yourself, but here's what a lawyer adds. We know how to evaluate discovery. We can negotiate for non-moving violations sometimes, no points, no insurance hike. We can appear remotely so that you don't miss work. And we know the small procedural details that can make or break a case. For example, I once had a case where the radar serial number didn't match the calibration certificate. That single digit difference got the case thrown out. These are the little things you only learn after years of doing this. Sometimes the smartest move isn't to go it alone. If you're unsure, reach out. I do this every day and can guide you through it. At your hearing, you'll appear before a magistrate by video. The officer will be called as a witness and sworn in. The magistrate will ask the officer questions to describe their actions. That's called direct examination. Then it's your turn. You get to cross-examine the officer. Now, this is something lawyers like me trained for years to do, and you'll be doing it all with little to no training. But all hope is not lost. If you prepare and keep your questions short and focused, you can still make your points clearly. Here's how. Lead the witness. Ask yes or no questions that guide them. One fact per question. Keep it tight. Don't argue, just ask. Use your discovery to highlight inconsistencies. No emotion, no questions you can't back up with fact. It's not personal, it's business, and you need to be factually accurate and not get emotional. Saying you were not speeding is one thing. Showing how the officer might be wrong is another. For example, did you know that while a laser measurement of speed might be accurate, at 1,000 feet, the laser beam is 4 feet wide? That means it might have hit something else. It's not a straight pinpoint like in the movies, but you need to prove this in court with the proper documentation and testimony, either through your witness or cross-examination. It's not easy, but it is doable. Your questions should be short, make one point at a time, and lead the witness to your argument's point. You can't wing this. You need to prepare. Here's an example. Officer, According to your notes, the radar calibration was last performed 8 months before my stop, correct? After both sides speak and you get a chance to make your argument as to why you should be found not guilty, the magistrate will make a decision. If you're found guilty, they'll set a fine amount and give you a short window to pay. But here's something most people don't know. Even if you lose, you're entitled to a trial de novo. That means a new trial. That means you can request a brand new trial before a real judge, not a magistrate. To do that, you must file the proper paperwork and make the request within 5 days of the magistrate's decision. That deadline is strict. If you miss it, you lose your right to a new trial. You can get the trial de novo form from the clerk's office at the courthouse or download it from the Connecticut Judicial Branch website. You'll need to file it with the same courthouse that handled your ticket or the email to the court clerk who sent your original hearing notice. And this is important, send a copy to the prosecutor's office too. That ensures everyone is properly notified and avoids delays. Once you've filed it, your case is reset for a brand new hearing before a judge. It's a clean slate and a second chance to fix mistakes, add new evidence, or bring in a lawyer to take over your defense. Many of my clients who tried to handle their ticket alone come to me at this stage. It's okay. It's not too late. That's why this system allows for a do-over, to make sure justice is done right. The problem is that if we come in at this stage, it's going to cost more because not only do we have to defend you, but we have to clean up a bigger mess. If you'd like help defending your ticket, or if you want a discovery request written correctly, click the link below. I'll send you a discovery request list of things to ask for that could help you. And if you handled your ticket yourself but found this helpful, I'd be truly grateful for a 5-star review on Google. It helps other Connecticut drivers find real, trustworthy information. I'm Attorney Jay Ruane. Stay safe on the road, and remember, information is power, but preparation wins cases. Thank you.